Stay tuned for Legal Straight Talk.
Is this reality? No, I don't feel okay. I need my kaleidoscope of colors to lead the way. I'm riding in my car and I'm coming on around the bend. It's a chase, this twisted race. I'll be on top again. I'm not gonna let you take me down. It's gonna be the whole 9 yards or nothing.
Welcome to Legal Straight Talk. I'm Brett Harrison, and today, again, for part 3, we have Richard Left with regarding to real estate and buying your first home and closings. Welcome again, Rich.
Thanks for having me.
Okay, today I want to focus in on last show. We talked about when you finally have to hire your attorney, and we talked about possibly reviewing contracts. Here's a term that seems to always come up, but I think people don't really understand what it means. Contingency clauses in a contract for real estate. Why don't you explain how contingency clauses pop up, what it means, and what do we do with it?
Okay. One of the most important contingency clauses in any real estate contract is what's called a mortgage contingency clause. Most people who are going to purchase property are going to go get some kind of a loan from a lending institution. They're going to go try to acquire a mortgage and acquire a loan commitment. The most important provision in the contract itself is that mortgage contingency provision, because people could either jeopardize their contract deposit or they could be successful in getting their loan. So the attorney who's negotiating that mortgage contingency provision has to do a good job on that, because that could actually jeopardize a client's contract deposit.
So let's take a step back. So now, just for a little bit of to rehash some of the things from the past and bring it up to current. You found a house, the person found a house that they like, they put in an offer, initially it's accepted. They then are told, okay, tell us the name of who your attorney is and we'll send contracts. And that's where your real money is made. That separates the boys from the men, so to speak.
Exactly.
That know what they're doing in this. Contingency now then comes to when you say, okay, now that you got pre-approved, now you need a contingency to give you time to get an approved mortgage so that you can comply with whatever terms are in the contract.
So usually in New York, the typical time to obtain a mortgage, and this is put right in the contract in that contingency clause, known as the mortgage contingency clause, is 45 days in New York. And that time starts running from the time that they receive fully executed contracts. So the process goes like this. The seller's attorney prepares the contracts.
Always the seller's attorney?
Seller's attorney always prepares the contracts.
So if you're buying a house and the seller's attorney says, no, let your attorney do it, does that usually mean what? That they're not familiar with preparing these contracts?
I've actually never seen that happen. So the seller's attorneys usually are more than happy to prepare it. I've actually never have seen where they said, oh, it's okay, you could prepare the contracts.
Okay. So now continue, I'm sorry.
So once the seller's attorney prepares the contract, he forwards it to the purchaser's attorney. It's at that point in time that the purchaser's attorney goes through the contracts and makes the appropriate changes that best protects his own client.
Now, what's in that contract and what they sign, there's nothing outside that you say, you don't want to hear, well, don't worry about it. Don't worry about putting it in the contract because we've already agreed to that. Your counsel to clients would be, that's not true.
Exactly right. If it's not in the contract, it's not binding. It has to be within the four corners of the contract, and it has to be spelled out pretty clearly in the contract. And the more clearly you spell it out in the contract, the less problems you're going to have later on if problems do arise.
Now, what kind of there's the mortgage contingency would be, there's a lot of different contingencies. That's one.
Well, the mortgage contingency, as we had discussed previously, most people can jeopardize their contract deposit by not making a good faith effort to obtain their mortgage.
What is that? There we go with the legal terms. That's why it's called legal straight talk. Let's take it out of the legalese and put it in plain English.
Once a contract is signed, the purchasers then take that fully executed contract, the contract that's signed by all the parties.
Okay.
They give that copy of the contract to their mortgage banker or their lender, and then their lender tries to acquire them their actual money or their loan or their mortgage commitment.
Now, when do you, like, when they say, all right, we're going to put 10% down, 20% down, does that come with the executed contracts?
What happens is usually when the attorney receives the signed offer and agreement, there's usually amount specified for the contract deposit. However, when I'm representing a purchaser, I want to try to have them put down as little as possible. When I'm representing a seller, I'm trying to get the greatest amount down as possible.
Okay. Now, from a purchaser standpoint, what's the minimum that you usually, is that negotiated again?
Well, sellers usually always try to get 10%, which they used to always get. These days, it's pretty common for 5% to be a common amount to be put down on the signing of the contract.
Now, will they send that money or you'll send it from your attorney account? What's typical?
Once the contracts are negotiated between the seller's attorney and the purchaser's attorney, the purchasers will meet with their attorney in the purchaser's attorney's office. They'll sign the contracts, and it's at that point in time that the purchasers will write a check, usually a personal check, and that check gets made payable to the seller's attorney as attorney. And what that terminology as attorney means on the check, it means that that attorney must deposit that contract deposit into his attorney escrow account.
Now, when you send that, the signed executor or signed contracts with the check, and the other attorney, the purchaser's attorney, the seller's attorney, puts it in their account, does that mean they have to now stop showing the property?
Yes, once the contracts are fully executed, the listing real estate broker, will, if it was on MLS, will then mark it in contract, and they will change the status of that property.
Now, when you say MLS, that's through everybody who wants to look at that house who has a realtor will see it has to be registered on the MLS?
Yes, that's an acronym for Multiple Listing Service, so that's correct.
Okay. Now, when you first, I'm just take a little bit of a step back. When you have you give your attorney, the purchaser's attorney, like yourself, the contract, how long should it take before it's all executed, all the addendums, any other aspect is corrected and agreed upon? Does that take 4 months, 1 month, 1 week?
Usually it takes days, and I'll tell you why. Usually when a purchaser finally has an accepted offer, they don't want to lose the house. At that point in time, they've decided this is the house they want to buy. Right. And they're afraid that somebody else is going to come along and maybe offer more money. So once they have their attorney, they have an accepted offer, they want the purchaser's attorney to negotiate the contracts as fast as possible and get them in contract so they do not lose the house to anyone else.
What are the typical areas that you'll talk with the other attorney, the other side, as from the purchaser to the seller, that would be maybe another contingency or an addendum, something in addition to what's in the four corners of the contract that will be also part and referenced in the contract?
One of the biggest issues that comes up and affects people obtaining a mortgage has to do with certificates of occupancy.
Which means what?
In order to sell the house, the seller needs to have the proper certificates. It means they need the proper written permission from the town for the actual structure that's there. For example, if somebody adds a second-story addition onto their house and they never got the proper permits and they never had it signed off at the end of the construction by the building inspector, they don't have the certificate of occupancy for that. As a purchaser's attorney, you never want your client inheriting somebody else's headache. So you want to make sure that the seller has all the proper certificates for that particular structure.
For example, if they dorm at a Cape, they might not, and let's say it was done 20 years ago, they might not have had it checked. It might not be the right windows. It might not be whatever. In order to get a proper signed off, they may have to make corrections.
That's absolutely
right. Could be 1,000, could be 10,000, could be 5,000.
And it's very time-consuming as well. And people and sellers didn't do it on purpose. A lot of them, it was inadvertent. They didn't know that the contractor didn't do what the contractors were supposed to do. So it could be 10, 20, 30, 40
Can
years
they actually,
ago.
can they actually ask them, you got to take down this garage?
Well, what happens is usually if they don't have the proper certificates of occupancy, they have to go through the whole permit process.
Is that, I guess it depends what county and what town or village, but is that usually a lengthy process?
Depending on the municipality and depending on the structure that was built or that they don't have the certificates for, it could be costly and it could be time consuming.
Now, will you tell your client, because they're eager to, they finally found a house, they're eager to just say, don't worry about it, don't worry about it. Does it take a long time to get an answer if it'll pass or if there's corrections that need to be made?
Well, when we were discussing about a good real estate broker on the previous shows, it's very important for a good real estate broker to tell their seller before they list the house to do their due diligence or to do their homework and find out what certificates of occupancy you have, were there any additions, and if there were, let's obtain them before we list the house so that we know we won't have any problems selling the actual house.
Ah, okay. Because I know people will say, don't worry about it, I like the house the way it is, but there's another part to that, is that my understanding, and correct me if I'm wrong, is that a bank might not approve or give a loan. They may make it contingent upon all of these, whatever is outstanding.
Absolutely.
Certificates of occupancy.
When you go for a loan and you're trying to obtain a mortgage, there will be a bank attorney throughout that process. And that bank attorney, when he receives the title report from the purchaser's attorney, there will be a certificate of occupancy search. There'll be a building and violation search in that title report.
Is that on almost every bank or every lending institution will do
Yes,
that?
they'll all do a CO search.
The only time that's not happening is when you're paying cash for the house.
If you're paying cash, then it's your option whether you want to purchase it in that condition without all the certificates. If you're getting a great deal and you're paying cash, you might say, you know what, I'll just deal with it. But if you're going for a loan, you want to make sure that everything's in order because the bank's not going to lend you the money if it's not.
So it's not going to go away. They're not going to not realize it, these lending institutions.
No, they're going to pick it up these days. It's not like it was 10 years ago where you could just sign and they'll lend you the money. All the I's are dotted, the T's are crossed, and everything's got to be right.
Well, all right. Now, let's say you mentioned title insurance. You said, well, the bank attorney or the lending institution's attorney is going to order title. I know what that means, but let's say, actually I don't. It's a little confusing.
Okay. A title report does a search on the property. They go back, they do a 40-year search. They go back to see from all the owners to make sure that the person actually selling the property has the absolute right to sell the property. When you eventually close, you receive a title insurance policy. That policy ensures that if anybody, after you purchase that house, comes along and says, hey, Mr. Jones, who sold you that house, wasn't the real owner, I'm the real owner, you're insured and you won't lose any money. So the title report goes back, they do a search, they run the chain of title to make sure that the chains all match, that they're all proper. They do, as we discussed, their certificate of occupancy searches, they do bankruptcy searches, they do judgment searches, they run...
Well, would you want, now if you find that there's a judgment, even if it's for as small as $1,000, $2,000, that could actually hold up this sale.
It can. It's what's called an impediment to title. So you want to make sure that you're getting clean title and there's no judgment. Once again, if you're borrowing money, that bank is going to want to be in what's called first lien position. When their mortgage gets recorded, they lend you the money, they record a mortgage to secure their interests. They want their mortgage to be in first position. They don't want any judgments or anything before them.
Well, wouldn't you, as the attorney, if you found out there was a judgment, would you make that a contingency that at closing, let's say it was $1,000, that this has to be satisfied?
Yes, there's provisions in the contract that...
Which happens. It's not unusual.
Right, and there are provisions right in the contract that any impediments to title, liens, judgments must be cleared up prior to the closing of title.
Because a lot of collection attorneys that put judgments and keep reinstituting them back and making sure they're current will do that exactly for that provision. So that when somebody does sell the house, boom, anybody that does a search will say, wait a second, there's an impediment now to selling your house. Now you have to satisfy me before you'll even be able to sell this house.
Exactly.
It's not unusual for that to happen.
No, that happens, and that's how a lot of people who have judgments, they have to wait till people actually sell the homes to collect.
But now there's also mistakes made too that's listed as a judgment that's been satisfied.
Or there's people who have the same name as the seller, and it appears as if it's a judgment against the seller, but it's really somebody else. So to clear it up, the easy way to clear it up is at the time of closing, they just sign affidavits that those judgments weren't them, and the title company will omit them.
Now, let's say you rely on this title company because you have title insurance, which, by the way, who pays for that?
It's the purchaser's charge for the searches.
Do they have to?
Yes, because the lender is going to require them to get what's called a loan policy. So for the amount of money that you're borrowing for that lender, they're going to want a loan policy. The bank does.
How much? Let's say you're buying a house somewhere between $500,000 and $700,000 in the loan.
It's based on a set table. The premiums are state regulated, and it's based on the purchase price. So it could be a few $1,000s depending on the price of the house.
But now you could also put that into your closing costs. A lot of people do.
It's considered part of the closing cost, the title insurance.
So now let's say the title company makes a mistake. They told you everything is clear. You're in the house a year, and you find out, wait a second, the title company never told me about this person that says I don't have good title. It's not really my house. Can you go after, theoretically, the title
Well, you have the
company?
title insurance, and that's exactly what you do.
That's one of the reasons you do have it.
Absolutely.
And how long is that good for? That
Ever.
insurance?
You're going to walk away with an owner's policy or a fee policy.
For that one-time fee. It's not a continual fee.
It's a one-time fee that you're going to pay at the closing. And regardless, while you own that property, if somebody comes along and makes a claim to that property, you could put a claim in. It's called a claim with the title insurance company.
Does that happen a lot?
It happens more often than you think. There's a lot of fraud out there. Things happen. And it's a requirement by the lenders. And even if somebody's paying cash, every attorney will advise their client to obtain an owner's policy.
And if you're representing a buyer that is buying is buying the house cash without any type of mortgage, will you, if they refuse, they say, "Nah, I don't care about it. I'm tired of spending the money." Will you actually have them sign a document that says that you've advised them?
Absolutely, yeah. That they went against legal counsel, that I advised them that they should get an owner's policy. But most clients and most builders or people who are paying cash do want that policy.
I think it sounds like they'd be foolish to take essentially you're saying without that policy, you're taking the representation of an owner who arguably you don't know. You're saying, no, this person's trustworthy. He told me he's good for it or she's good for it. You're talking on a large purchase. That's crazy.
Right. You're purchasing a home for several $100,000. The least thing you could do is buy yourself some protection.
And that's what it's about.
Absolutely.
Now, let's go back to contingencies. What other contingencies would you put as an attorney?
Well, like I was saying before, certificate of occupancy seem to be one of the biggest issues that arise. Not only is it for dormers, as we previously discussed, decks are a big issue.
A lot of people do it themselves. They don't really, I don't know if they actually follow, quote unquote, the code. And that's where it comes into play.
That's exactly where it comes into play, because if they don't have the certificate of occupancy for the deck, once again, they're going for a loan, and if it comes up in the process, they're going to have to rectify the situation.
They may even have to take it down.
Sometimes they do. One way to rectify it, instead of getting a certificate of compliance, which you go through the town, they come inspect, they make sure it meets the code, they'll issue a certificate of compliance. But if they know that that deck that they built is too large and the town's not going to approve it, sometimes they remove the actual deck so that they can get to closing. And in the contract, there's usually a provision that even if the homeowner removes that deck, they don't get a reduction in the purchase price.
Oh, wow.
So you have to know, it's very important to know beforehand what you're purchasing. And for a seller, it's very important to know what they have certificates of occupancy for and what they have certificates of compliance for.
So let's say which unfortunately happens a lot, let's just take Nassau County. I'm sure it's Suffolk as well, but where they have what I call an illegal rental. They have a two-family that's really only one family, so they put in an additional kitchen, another entrance. What happens there? Do they have to take down the whole kitchen?
Well, that's good.
And let's say other plumbing and, what happens?
Well, what happens is if that purchaser is going for a loan, during the loan process, the bank is going to send in what's called an appraiser to the premises.
They actually go in the house?
Yes, the bank's going to want to know what this house is worth. So they send in an independent appraiser who goes through the house and evaluates the house and gives the bank what they feel the house is worth based on comps or comparables to other houses that sold. When that person walks through that house and they see that there's 2 kitchens or an entrance, it's going to be picked up by the bank and it's going to be an issue.
When they look at it, the appraiser for the bank, they have a list of what the house is, quote unquote, registered as. It'll say 4 bedrooms, 2.5 bathrooms, 1 kitchen, 1 basement. It's very specific.
Right. So they'll know whether it's a 1-family or a 2-family dwelling.
And let's say I want, as the purchaser, I want to buy it because I intend to, rent it out and help me because it's so expensive. What happens in that situation?
Well, 1 or 2 things are going to happen. If they're going for a loan, they're going to have to remove that second kitchen. If there's an illegal bathroom in the basement, they're going to have to remove it in order to be in compliance because they're not going to get their loan if this is out of compliance.
Who will check? You mean the
appraiser's
will come back?
going in. The appraiser's going into the house, and if they report that there's 2 kitchens, it could be a problem. But even if the purchaser wants it with 2 kitchens and they know it's not in compliance or it's an illegal 2-family, I wouldn't recommend them purchasing an illegal 2-family
But now,
house.
who chooses the appraiser? Can I say I have a friend that's an appraiser? What does the bank say? We'll choose.
It's chosen by the bank, and it's an independent appraiser, independent company. So the purchaser has nothing to do with it.
Oh wow! So there's no way around that.
No, so if I have a client, they want to buy an illegal premises, I would advise against it, or sometimes not even represent them.
And what typically happens? Some of them will actually put the kitchen back.
What they do in their own house.
But I'm saying
who
that's
knows?
not unusual.
If that's what they want, they can, I guess.
But
I
you're
wouldn't
long
advise
gone
it.
at that point.
Yeah, I'm out of the picture at that
You're
point.
just there for the purchase,
Right, and make
handing over
sure-
the keys, and you're done. What they do after that, that's up to them.
Who knows?
But it's not unusual, though. From what you
if
hear.
my clients do it,
Not
they don't
your
tell
clients,
me.
I'm just saying from what you hear. This guy,
You know what? Nassau County and Suffolk County, they're pretty strict. So
the fines are pretty heavy,
and
aren't
the
they?
fines are heavy, so you will not. I don't see a lot of illegal 2-families because they have Nassau and Suffolk County have great building inspectors, great code enforcement officers,
Right.
and people who are living in Nassau and Suffolk County don't want to deal with the extra cars or the extra noise with 2 families. If they worked hard to buy a 1-family house, they don't want to live next to somebody who's having parties or extra cars or an animal house. So usually the neighbors will report them themselves.
And what kind of fine? I mean, then what happens? The inspector then comes.
A neighbor can report them,
Right.
and the building department will send somebody out, and they'll actually inspect. They'll knock on the door, ask to do an inspection of the house.
And then do they get a ticket?
They could be fined, and if it's not remedied, they could be dragged into court.
But even if it's remedied, they still may get a fine.
They can. But then, if it's an illegal 2-family and you have another family living in there, they're going to have to be evicted.
Oh, wow. So then what happens to, then they have to, let's say these people won't leave. I guess that's a tenant court. Landlord,
That's
tenant.
a separate.
So there's a whole host of problems when you have an illegal 2-family.
Right. And
It's not just the fines, and it's not just going to court. You may also then end up in landlord-tenant court because it's an illegal rental. And then, actually, from my understanding, the tenant could request all the money they paid you.
there's different
There's a whole host
situations
of
and
problems then.
remedies with
So then
landlord-tenant.
the problem still continues.
It does. So in Nassau and Suffolk, if it's a 1-family neighborhood, the neighbors are not going to want a 2-family house in their neighborhood. So if
Right.
somebody's doing it, most likely they're going to be turned in, and it's going to be nothing but bad news for them.
Okay. Well, we only have a couple of minutes. What would any quick advice when hiring an attorney to represent you as a purchaser?
These days, with real estate transactions, no deal seems to be easy. There seems to be issues regarding mortgages and people obtaining mortgages. There's issues, as we discussed, with the certificates of occupancy, with the legal decks, illegal pools. There's issues with abandoned oil tanks, with not having the proper certificates, which seems to be very big on Long Island, where people didn't properly abandon their oil tank, their buried oil tank, and they didn't do it the right way. And a purchaser is going to want a certificate that it was done by a licensed company. and that's a big issue as well. So there's a lot of issues that arise. So the most important thing is to hire an attorney that really practices in real estate law and will avoid a lot of problems later on.
Okay, well, thanks for that good advice. There'll probably be another part 4 and maybe part 5 by the time we finally get to the closing, Rich. But I'd like to thank Channel 20 and Cablevision. If you have any questions, you can always contact us at our website, which is at www.hlgny.com, or you can call us directly at 631-465-9797. Thank you.
Hi, I'm Jerry Parisi. Join Tom Neely and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.